This is Talking Law with Despina Prialo from Prialo Legal in Runaway Bay, with us each and every Thursday morning. And if you have a question to do with the law, then why not drop it to us, and we'll be happy to pass it on and ask Despina on your behalf. Just send it to breakfast97 at superradionetwork.com.au. That is breakfast97 at superradionetwork.com.au.
And for this topic, it is about claims made against deceased estates. So there's been one big story that's popped up in the news recently to do with cricket champion Dean Jones. But this situation in particular could really happen to anyone, right, Despina?
It can, and we've talked on the show before about people making claims against deceased estates, particularly who can make a claim, and we focused on that before. But what I want to focus on today is whether you can prevent those eligible people at law, whether you can prevent them from making a claim at all, and what can you do about preventing and or minimising, and how can you go about it? So what is the best course of action if you think someone's going to make a claim, or you're actually removing someone and you're not giving them anything under your will? What's the best course of action for you?
All right, and I think this is something that people will come up against quite a lot over the years, either for themselves, and there's someone in particular in their family that has got in the way, or someone that they specifically want in their will, or vice versa, or being on the receiving end as well. So I think it's something that we'll come across at least once in our lives.
Oh, 100%. So if we start at the beginning about the eligible persons, so I think that's important. So when people make a will, they think, well, I can do whatever I like with my property and my assets, and I want to give it to whoever I want. And that, in theory, of course, it means your property, you can do what you like, but you must be aware that at law, there are certain people that have a right to make a claim against your estate, and it includes twofold. So people who are named as beneficiaries, I should say, who want more, okay, from what they were given under the will and the estate, and those who were never named in the will, so they were not given anything and want something from the estate. So it can happen in both instances. And the people that can claim, and I'll just mention it quickly so people can understand and put it into context. So we generally have three categories in Queensland. New South Wales is similar, but New South Wales have got a couple of extra interesting categories. So in Queensland, we're talking about spouses. So we're talking about spouses, and that includes the husband and wife scenario, the de facto relationship, and there's certain definitions and thresholds you've got to meet. And then we're talking about the civil partnerships. Okay, so that all is under the heading of spouse. Then you've got child. Okay, so you've got your own children. It includes adopted children, and it includes stepchildren, which is a really interesting category. And in Queensland in particular, it includes a category of a child called en ventre sa mère.
En ventre sa
For our
mère.
French listeners,
Yeah.
what on earth does that mean?
In the mother's womb.
Ah.
Yes. So there's a section in the Succession Act in Queensland which says that a child, obviously in the womb, so a woman who is pregnant at the time her partner may have died, so as long as that baby is actually born and survives by 30 days, they're also a claimant, can be an eligible claimant under the heading of child. And then you've got dependent. So someone who was wholly or substantially being maintained and supported by the deceased person at their time of death.
Sure.
Okay, and then they've got to be either someone under 18 or a parent of a child under 18. So there are certain things to meet there. But essentially, you've got those three categories. And in New South Wales, interestingly enough, I'll just mention quickly, you've also got grandchildren that can also possibly be claimants. And you've also got someone who has lived with you and is in a close personal relationship with you, in addition to all those other categories. Okay. So it's interesting, isn't it, whether, housekeepers come into it or carers come into it.
Yeah,
and there's been a lot of cases in New South Wales about that. Yeah. So those are the eligible claimants under the Succession Acts, both in Queensland and New South Wales. They'll be similar in other states. So therefore, you've got to be aware of that. So when you're making your will, if you want to cut, someone out, a child out, for example, for whatever reason, you can do that. Look, it's your decision, your personal choice, but you must be aware that they can still make a claim. Now, what can you do about it? And this is what I want to get to. So when you do a will, first of all, don't go to the newsagent and do it yourself. It's, that's a big no-no, because
But it's 1995.
you really don't know what you're doing. And I say that very nicely
Yeah.
because you're not a lawyer and you don't know how to draft it. And that those wills that you get from the newsagent are extremely basic, and no one is there to guide you through what to look for and what to cater for. So try not to do that
I'm
if you
sorry,
can.
can you actually get will
Yeah,
templates?
a kit
Kits
from the
and will
newsagent.
kit.
Yeah.
You can. It's not.
You're making a joke.
No.
No offense, news agencies out there. That's pretty cool.
Oh,
But
they just sell it as a matter of
Oh,
course, but
that's
it's not
incredible.
recommended at all. So go and see a
buy
lawyer.
a lotto. Get your will done. Add that to the shopping list. That's incredible. I'm sorry, I didn't know that.
Yes.
Oh wow. Okay, go on. Yes.
So the point is to go see a lawyer.
Yes,
Yes,
for sure.
That's the high recommendation. And then go see a lawyer who does wills and understands. So when you do the will, if you want to be honest with your lawyer, because your lawyer can't cater for your will properly unless you tell them all of your assets, all of your liabilities, joint or otherwise. And then who's in your family. So those are the first questions I ask. Let's talk about your family. Are we talking a blended family, mixed family? Do we have children from other marriages, second marriage, third marriage? It makes a difference. Be honest. Then the next question, is there anyone in your family or otherwise that is lurking around that might want to make a claim? Then it all gets flushed out. Oh, well, I don't want to provide for this child because of this reason. I say, okay, that's your choice, but let's talk about it. And let's talk about the reasons why. And then the recommendation is always that we document it. And this is the point I want to get across this morning.
And so you're suggesting that you need to explain why you've decided to cut someone out of the will.
Yes, because for the very reason that when you die, you're no longer here. So you can't speak for yourself. So who can speak for you? It is your will and how you've documented what you want to have happen. And then if it's a long story and a long history about why a person is being cut out of the will, explain it in a document that I call a memorandum of wishes, which is attached to the will, and you can put it in your own words and explain the history and why you've chosen to remove this person from your will.
And does this have to be shared with everyone in the family?
Well, interesting question. So it's not like the movies where you all sit down in a room and there's the reading of the will.
This is what I'm picturing. But of course, like obviously there are family, I know family secret sounds very cliche, but there are things within the family and very personal, awful things that could happen that you would never want people to know. And then it's like subconsciously, if you know you're going to a lawyer going, oh my gosh, everyone's going to find this out when I'm gone, obviously that could cause a few issues. So,
Yes, so potentially that can be discovered by all, and there are certain rights people have that can obtain copies of the will, even if they're not named, and there's differences in different states. So potentially it can be read by definitely your executors, your beneficiaries, and potentially other people who aren't beneficiaries. But if you don't do it, then if there's a dispute later, someone makes a claim, the court is only left with what is written. You're not here to explain your position as the testator or the testatrix who made the will. So you've got to document it, put it in a document, specify why, what's happened to the relationship, what have they done to you or not done to you or failed to provide for you. Because when you're gone, as I said, this is the only thing that can speak for you, and everybody will be providing their own affidavits in court. And they're usually self-serving. So it's this he said, she said situation. If you don't document it, then the court is only left with what other people put forward.
And if you go to that trouble of explaining why you want someone cut out of a will, does the court necessarily have to follow that?
Well, this is about giving the court enough information to show what your intentions were at the time and the reasons why you have removed someone from your estate. And then the court will take that into account as one of the many factors to decide if a person's claim is successful or not.
So it can't be as simple as, I don't like Auntie Barb, she was mean to me at the Christmas party. That's not going to cut it.
Well,
It's
I
gonna-
don't think that would cut it, no.
Alrighty, great advice there as always from Despina Priala from Priala Legal, answering all your questions about the law. And Despina, if anyone wants to get in touch with you directly, where can they go?
So they can ring our office, 55291 and talk to myself or my lovely staff about any query that they have. They can email us at info@prialalegal.com.au, and they can look at all of our segments on YouTube.
Yep, all of the years worth of Talking Law is available on YouTube. Yep.
Lovely. Well, thank you so much again, Despina. We will see you in person next week.
You definitely will.